Hi, my name is David Fraser, and I'm a privacy, internet, and technology lawyer with the Canadian law firm McGinnis Cooper. In this channel, I try to provide educational and informative content about Canadian privacy and technology law. In my legal practice, I exclusively advise businesses on matters related to privacy and technology law, but I'm sometimes asked by individuals about the use of home surveillance cameras. Because of advances in technology and low cost, they're everywhere. The rise of home delivery has led to porch pirates who steal packages, and people want to deter that or want to try to catch porch pirates in the act. If you keep an eye out walking down a suburban street, you'll often see them. Doorbell cameras are very popular, but so are other cameras. The purpose of this discussion is to review the laws that do and do not apply to individuals who use these devices on their own private property. At least in this discussion, I'm not going to talk about the laws as may apply to companies that provide these services used by individuals. I'm going to start with my usual disclaimer. This is intended to be a relatively general overview of the law for educational and informative purposes only. This is a complicated area of the law with many nuances. I'll be talking about general rules, and there may be some exceptions to those rules. If you have any specific legal questions, or if you're dealing with a situation yourself, you should seek qualified legal advice. All opinions expressed in this video and on this channel are mine and mine alone, and should not be attributed to my law firm or any of its clients. And of course, I'm only talking about the law in Canada. Privacy and internet law can vary significantly from jurisdiction to jurisdiction. Many people are familiar with privacy regulations like the Personal Information Protection and Electronic Documents Act, or the Provincial Freedom of Information and Protection of Privacy Acts. Businesses are regulated by commercial privacy laws, whether federal or provincial. Government and police are regulated by public sector privacy laws. But the personal or domestic collection of personal information is largely unregulated in Canada. Commercial privacy regulations do not apply to private individuals collecting, using, or disclosing personal information for their own personal purposes. For example, the Personal Information Protection and Electronic Documents Act, known as PIPEDA or PIPEDA, only applies to the collection, use, and disclosure of personal information in the course of commercial activity. And just to be more clear, paragraph 4.2b of that act excludes personal or domestic purposes. It says, this part does not apply to any individual in respect of personal information that the individual collects, uses, or discloses for personal or domestic purposes, and does not collect, use, or disclose for any other purpose. If you're collecting personal information, which includes video and images that include a person, only for personal or domestic purposes, that is specifically excluded from the operation of the Act. The Personal Information Protection Acts of British Columbia and Alberta are very similar. For example, paragraph 3.2a of the BC statute has an exclusion that's very similar to PIPEDA's. This act does not apply to the following: the collection, use, or disclosure of personal information, if the collection, use, or disclosure is for the personal or domestic purposes of the individual who is collecting, using, or disclosing the personal information, and for no other purpose. Just because this activity is not captured by our general privacy laws, other laws may apply. Our criminal code includes offenses for voyeurism and the interception of private communications. The crime of voyeurism was added to the criminal code relatively recently. It involves surreptitiously observing or recording where there is a reasonable expectation of privacy. Paragraph A makes it an offense to observe or record in a place in which a person can reasonably be expected to be nude or to be engaged in explicit sexual activity. Paragraph B makes it an offense where the recording or observing is done for the purpose of observing or recording a person in such a state or engaged in such an activity. Paragraph C covers a broader range of observation or recording, but where it's done for a sexual purpose. People should be aware that the courts have held you can have a reasonable expectation of privacy in a relatively public place, and that the expectation of privacy can vary according to the method of observation. For example, you may not have much of an expectation of privacy with regard to being observed by somebody at eye level, but you may have a protected expectation of privacy from being observed or recorded up a dress or from above looking down somebody's top. So don't point to camera where someone has a reasonable expectation of privacy. This would include pointing at a neighbor's windows, fenced backyard, pools, hot tub, etc. Audio recording is particularly hazardous in Canada. Using a device to knowingly intercept a private communication can be a very serious offense in Canada, and private communication can include just a simple conversation. If your camera can record audio, don't put it where it might record a private communication or conversation, or disable that feature. And be careful. You may have a camera on your fence post that's exclusively pointed at your property, but it may capture private conversations among your neighbors on the other side of the fence. Now, consent is a defense to a charge under this section, but it's unclear if signage can create adequate consent. In addition to the criminal law, people should also be mindful of the laws of where you can be sued, kind of civil law. This includes the law of nuisance, the law of trespass, and privacy claims under intrusion upon seclusion and some provincial privacy statutes. Nuisance is a very old and well-established legal claim. It boils down to unreasonable interference with the ordinary enjoyment of property. A lot of traditional old nuisance claims relates to things like noises, bad smells, smoke, things like that, but we're starting to see cases where people claim that someone's use of surveillance cameras is interfering with their enjoyment of their own property. The case of Suzuki and Monroe from the British Columbia Supreme Court in 2009 is instructive. In this case, the Suzuki sued the Monroes for having a loud air conditioner and for having a surveillance camera that included part of the Suzuki property. In finding in favor of the plaintiffs, the judge wrote, "I have no doubt that a surveillance camera continuously observing the entrance areas of a neighboring property or any part thereof in these circumstances is an intolerable interference with the use and enjoyment of the neighboring property. No useful purpose of any kind is served by having the camera directed at any part of the Suzuki property. I am forced to conclude that the Monroes installed the camera and refused to remove or redirect it, at least in part in order to provoke and annoy the Suzukis. Acts done with the intention of annoying a neighbor and actually causing annoyance will be a nuisance, although the same amount of annoyance would not be a nuisance if it was done in the ordinary and reasonable use of the property." So it's important to note that the judge said the use of the cameras was not really necessary for any legitimate purposes of the defendants. If it had been legit, it might not have been found to be an actionable nuisance. We'll talk about another similar BC case coming up in a bit. Trespassing is unlawful. It can be a criminal offense, a provincial offense, or something you can get sued for. Don't enter a neighbor's property to install or locate a camera without their permission. Putting a camera physically on a property that is not yours without permission is also unlawful. In addition to the more traditional torts that I just mentioned, we're seeing more pure privacy claims. In most common law provinces, you can sue or be sued for intrusion upon seclusion. It is, in summary, an intentional or reckless intrusion without lawful justification into the plaintiff's private affairs or concerns that would be highly offensive to a reasonable person. If you poke into someone's private life in a way that would be highly offensive, harm and damages are presumed. Some provinces have what are called statutory torts of invasion of privacy. Here's the gist of the British Columbia Privacy Act. It is a tort, actionable without proof of damage, for a person willfully and without a claim of right to violate the privacy of another. This means that the plaintiff doesn't have to prove they were actually harmed. That is presumed. Note the violation has to be without a claim of right or legitimate justification. It then goes on and says, "The nature and degree of privacy to which a person is entitled in a situation or in relation to a matter is that which is reasonable in the circumstances, giving due regard to the lawful interests of others. In determining whether the act or conduct of a person is a violation of another's privacy, regard must be given to the nature, incidence, and occasion of the act or conduct, and to any domestic or other relationship between the parties." Note it specifically refers to eavesdropping and surveillance in subsection 4, which reads, "Without limiting subsections 1 to 3, privacy may be violated by eavesdropping or surveillance, whether or not accomplished by trespass." For the use of home surveillance cameras to protect your property, paragraph 2(b) is important. It says, "An act or conduct is not a violation of privacy if any of the following applies. The act or conduct was incidental to the exercise of a lawful right of defense of person or property." Let's see how that plays out in practice. This specifically came up in another British Columbia case called Minikuchi and Liu, a 2021 decision from the British Columbia Supreme Court. This was another dispute between neighbors. For backyard privacy, the plaintiff planted 8 25-foot cedars and 20 10-foot cedars along the property line. This was the property line between the parties' homes. The plaintiffs had a pool in their backyard, and the defendants had one as well. Sometime later, the defendants asked the plaintiffs to top the trees because they were interfering with the defendant's view. The plaintiffs refused. So sometimes later, when the plaintiff was away from their home, the defendant topped numerous of the cedar trees. The plaintiff then installed cameras pointed at the trees, and the camera could also see into the defendant's backyard. So the plaintiff sued the defendant seeking damages and injunctive relief for trespass and damage to the cedar trees. The defendants filed a counterclaim seeking damages from the plaintiff for nuisance and for invasion of privacy by the camera. The defendant's privacy claim was dismissed because the use and location of the cameras was justified. Capturing a portion of the defendant's backyard was incidental, and the camera had been installed because of the defendant's trespass and topping their trees. The court also noted that it would not have been possible to record the trees without incidentally including some of the backyard. In some cases, there may be other rules that affect whether or how someone can install surveillance cameras. For example, in a 2022 Alberta court case called Lupiliac and Condo Plan 821 blah blah blah, the Court of Queen's Bench found against a condo owner because the installation of a doorbell camera violated the condo rules. A similar camera that had been installed on the person's patio was found not to be an issue. If you're a tenant, you'd want to check your lease or check with your landlord before installing any device outside your leased space. This would also include your door. Many cameras that people install to observe their front doors or driveways will also include coverage of public spaces like sidewalks and roads. There's a diminished expectation of privacy in a completely public space like a road or a sidewalk. However, expectation of privacy is not binary, but is more nuanced. So if it came up in a court case, the courts would likely do a balancing test. Is your legitimate need to use the device proportionate to the intrusion for others? Since most people use home surveillance cameras to deter or detect criminal activity, it's worth asking what to do if the police ask for your footage. With the increasing adoption of these devices, police are more commonly doing a video or CCTV canvass as part of their investigations. This involves going around the area to see if there are any cameras that may have captured something that can further their investigation. So if the police come knocking looking for footage from your camera, what should you do? Well, unlike businesses that are subject to general privacy regulations, you can give them footage without a warrant or a court order. That doesn't mean you have to. It's entirely up to you. Of course, unless they have something called a production order, which is a court order that requires you to provide it. Personally, I would ask them what they're investigating, and I'd decide whether to hand it over on that basis. And if you're dealing with the police to report a crime, and your camera's captured anything relevant, you can feel free to hand it over. So at the end of the day, what are the best practices? In short, don't be an idiot. Be a good neighbor and minimize any recording of anything that's not on your own property. Let people, residents, visitors, neighbors know what's going on. Talk to your neighbors. Put up signs. Your neighbors may actually appreciate that you have cameras. Certainly don't point it at any place you'd expect people to be nude or doing things. Think about what you're actually using the cameras for, and maybe you can adjust your settings accordingly. If you're concerned about prowlers at night, or someone on your property when you're not home, some of these more advanced cameras can be set to only record at night or when you're not at home. Remember that though an individual in their private capacity is outside of the usual privacy regulations, other laws and rules can still apply. Respect your neighbors and their privacy interests. So thank you very much for tuning in. If you have any comments on this video or any suggestions for topics you'd like to see discussed, please leave them in the comments below. I read and reply to all of them. If you find this sort of content to be interesting or informative, please subscribe. If you also click the bell, you'll be notified of any new videos as they're posted. And if you know someone who may be interested in this topic, feel free to share it with them. Thanks.